Why are drug DUI laws so different between states? Have you ever wondered why drug driving laws change so much from one state to another? It's a topic that affects many people, especially those who may find themselves facing charges. Let's break it down. First off, every state has its own legal system and priorities. This means that drug driving laws can differ significantly. For instance, when it comes to alcohol, most states have a standard blood alcohol concentration limit of 0.08%. But drug laws are not as uniform. Each state defines and enforces drug driving laws in its own way. One key reason for these differences is how states approach legal standards. Some states have zero-tolerance laws, meaning any detectable amount of certain drugs in the body while driving is illegal. Others may have specific limits for certain drugs, similar to blood alcohol concentration for alcohol. However, only a few states have set limits for substances like tetrahydrocannabinol, which is the active component in marijuana. Many states relying on general impairment laws, which requiring proof that the driver was impaired, regardless of the drug level detected. Another factor is the challenge of measuring drug impairment. Unlike alcohol, where blood alcohol concentration is a clear indicator, drug impairment is much harder to quantify. Different drugs metabolize in various ways, and their presence in the body does not always mean a person is impaired. This scientific uncertainty leads to different approaches. Some states focus on toxicology results, while others relying on observations made by law enforcement officers during field sobriety tests. Additionally, the legalization of marijuana in some states has influenced drug driving laws. States that allow marijuana use often have specific laws regarding driving under its influence. This can include limits for tetrahydrocannabinol or even zero tolerance for certain metabolites. In contrast, states that maintain stricter drug laws may have harsher penalties for drug driving offenses. Speaking of penalties, they can vary widely. Some states impose fines, license suspensions, or even jail time for drug driving offenses. Certain states may increase penalties for repeat offenders or if the offense resulted in an accident. The resources available for enforcement also differ, affecting how aggressively drug driving cases are pursued. From a criminal defense standpoint, these variations mean that a person charged with drug driving may face different legal strategies and consequences depending on where they are. Defense attorneys need to be well-versed in the specific laws and testing methods of their state to effectively challenge charges or negotiate outcomes. In summary, the differences in drug driving laws across states stem from how impairment is measured, the legal definitions used, the impact of drug legalization, and the penalties imposed. This patchwork of laws can create challenges for both those accused and those enforcing the laws. Understanding these differences is key for anyone navigating the complexities of drug driving charges.